Yeah, the way that you get a big result nowadays in court is very seldom with the verdict itself. Verdicts are very tough with the tort reform and all the advertising the insurance industry has done. It's hard to get jurors to give large awards anymore. But what we do is we do everything possible to give the jury an opportunity to do that. So, for example, rather than, if we have a brain injury case, rather than having a picture of a brain or a textbook, we actually have a model made. We have a model maker who will make a perfect model of a brain showing exactly where the brain damage is and what it looks like, so that when the doctor who's testifying explains it to the jury, we can get the jury out there feeling the model and touching it and seeing what it looks like and playing with it. And all of these things tend to cause the insurance company to get nervous about how much money a jury might give in a case like that. So while the reality is that we may very well end up settling the case, we want to scare the insurance company into thinking that the verdict could be very large. We want to get them concerned about that. Once we get them concerned, they normally come up with a reasonable settlement, finally, halfway through the trial, or maybe even when the jury's out running a verdict, and then we get the settlement for our client. And that's usually the best way to do it for the client. Oftentimes it's better that way than to end up getting a verdict itself.